attorney-client privilege in the guardianship and estate or probate context in Florida. Hello, my name is John Pinkowski. I'm an estate litigation attorney with Pinkowski Hauser in downtown West Palm Beach, Florida. We handle trials, disputes, and appeals of estates, guardianships, probates, wills and trusts, as well as related business and commercial and real estate litigation throughout Florida. Two very important decisions just came down over the last couple of months that give probate litigators in Florida a little bit more guidance, although experienced estate litigation law firms would tell you they didn't need the guidance. Why? Because the answers to these issues are in black and white. Why? Because they're in our evidence code and our legislature said so. They involve the attorney-client privilege for people in Florida. One recent case, the Vassallo case, was issued in October of 2016, confirming that there's an exception to the attorney-client privilege, that where people inherit from the same deceased person, an estate planning attorney for a deceased person who's a witness in some litigation, such as a will contest, has to testify as to why the client who's now deceased disinherited children, right? There's an exception or a carve-out to the attorney-client privilege. But what happens if there was a guardian of a person who had an attorney, and those communications were privileged? The person dies, the ward dies, and now there's an estate, and the personal representative of the estate is different than the guardian, and the personal representative doesn't get along with the guardian. There's a lawsuit, and the personal representative of the Florida probate wants the communications between the guardian and the guardian's lawyers. Who wins? In the Bivens case, B-I-V-I-N-S, 2016 Westlaw, 4702692, Southern District, Federal Court of Florida, the guardian won. Why? Just because the personal representative steps into the shoes of the deceased person does not mean that the personal representative can get the confidential attorney-client communications or documents between the guardian and the attorney, even though the guardian was protecting the ward, who's now the deceased person in the estate. This was a tension between the right of the personal representative to get information from the guardian who had confidential communications with his lawyer. My name is John Pinkowski. If you're involved in estate litigation, guardianship litigation, or probate litigation, and the attorney-client privilege comes up, or the accountant privilege comes up, the accountant-client privilege comes up, know Chapter 90, talk to your estate and probate litigation law firm in Florida, but also read the Bivens case, B-I-V-I-N-S. My name is John Pinkowski. This concludes my remarks about this federal court case and the attorney-client privilege.